What is discovery in trust litigation? I'm Daniel Hunt, a certified legal specialist in estate planning, trust, and probate law. When a trust or estate conflict evolves into litigation, one of the first steps in preparing for a trial is formal discovery. Discovery is a legal procedure in which both sides of a lawsuit discover relevant facts of the case in order to prepare for trial. Whether you're the trustee who's being sued or a trust beneficiary suing a trustee, you'll need to understand what facts can and can't be discovered and how to best approach the discovery process. The basic rule of discovery is you can request any information that is even remotely relevant to the issues within the lawsuit, or that might even lead to relevant information, so long as that information isn't privileged or otherwise legally protected. Here are some of the common tools used in a formal discovery, divided into two categories, of written and oral. There are four main kinds of written discovery. First, interrogatories. These are written questions directed to the other side. The other party must provide written answers under oath which can be used at trial. Second, requests for production of documents. These are written requests for a specific document or a class of documents likely to be relevant to your case. Third, requests for admissions. These are written requests to the other party to admit that a statement is true so that the case can focus on the main issues being disputed. Responses can be used at trial. Fourth, subpoenas. These are written court orders requiring one side or a third party to testify or produce physical evidence for inspection, such as medical, bank, or business records. Next, we have oral discovery. Depositions are the main form of oral discovery. These are in-person interviews with a party in a case or a third party directly involved in the case. The person being deposed must answer under oath. A court reporter typically writes down everything that is said and produces a written transcript. What is excluded from discovery? Some privileged information remains off limits during the discovery process. Generally, this includes attorney-client communications, the attorney's work product in preparing their legal case, trial preparation materials, and information that is irrelevant to the specific case at hand. California attorneys are bound by the California State Bar's rules of professional conduct to engage in ethical discovery methods. So what about cost? All parties pay the cost of their own discovery. If a party later files a motion to compel, which is asking the court to enforce a request for information relevant to a case, and the court grants that motion, the prevailing party may be entitled to their attorney's fees. For both parties, it's best to be forthcoming and provide the requested information. Otherwise, you risk paying the opposition's attorney's fees. While discovery can be costly, it can actually save money later on by encouraging the parties to settle the case and preventing or shortening a long and expensive trial. If you think of the trial as a poker game, discovery is like getting to peek at the opposing player's cards before the game even begins. Through discovery, both sides get a sense of the strength of their side's position. If you clearly have a winning hand, the opposition may opt to fold before the game even begins.
Well, I think I will call you on that one.
Now, a few words of advice on discovery. If you are a trustee, stay organized and keep accurate records of everything you've done in the trust administration. Always be honest and forthcoming. Provide all information to your attorney and the trust beneficiaries. If you're a trust beneficiary involved in discovery, you may bear the burden of proof. This means that you carry the responsibility to show evidence that the trustee has mishandled the trust administration. Because of this, you will likely be the party making the bulk of the discovery requests. As you approach discovery, think through exactly what information you want to request and what answers you'd like answered. Communicate all of this to your trust litigation lawyer. Speaking of which, remember that discovery often requires knowledge of evidence rules and other technical legal strategies. If discovery becomes necessary, you will want to hire an experienced trust and estate litigator to represent you and build your case. If you have any questions about the discovery process, please feel free to contact our office. Thanks.
We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.